two ago.
To test your research skills. You thought this was good.
Started off thinking, I confess.
Yeah, no, it's actually using it, not
Down here, is that for me as well?
Appeal partnered in the matter of London Borough of Redbridge and Stokes and Another and others.
My lords, my lady, good morning. Could I start with the homework, the note on judicial precedent?
Thank you very much for that. For myself, I find it very useful indeed.
I'm very grateful, my lord. Well, I was going to go through it very briefly, just to make a couple of observations, and also to show you the cases which are referred to. And my lord, you will see that I stuck to the letter of my promise not to do a flowchart, but in a sense, perhaps not the spirit, because I've set out different scenarios, which I think is inevitable, for reasons you will have seen. The premise of the note is that Cameron does not apply to injunctions. And the question which is posed then is how to reconcile, on principles of precedent, Ineos Gamel and Canada Goose. Particularly important as a first step to ask what is the binding reasoning of Ineos and Gamel in that scenario. And my scenario one considered in the note is if this court considers really that either of those cases, I'm picking the note up at paragraph 5, if this court considers that either of those cases decide as part of their binding reasoning.
I'm sorry, having said I found it so helpful, I've now lost it. So can you just give me a paper copy? No, goodness me.
I know it's heresy.
I can find it. I just need to do so. Just give me 1 sec. Sorry, I've had quite a lot of. I have it. Thank you.
So, well, scenario one, what I call scenario one, is if Gamel or Ineos decide as part of their binding reasoning that it is permissible, generally speaking, in other words, outside of the normally recognised contramundum categories, to grant final injunctions against newcomers. And one would then have to come to Canada Goose and ask how that sits with those cases. And this is where I've proposed two sub-outcomes, sub-categories. One is if it's possible to distinguish Canada Goose, for example, as applying only to protester cases. Of course, that introduces the kinds of distinctions which I apprehend the court may not be attracted by, but of course if that is a distinction that is valid, then there's no difficulty. This court then is bound on this scenario to follow Gamel and Ineos, because the point before you would have being decided.
I mean, it depends what the distinction is between protesters and what one might call squatters, if you like, or people squatting on land. And there are distinctions, but they're not, well, query what they are, precisely.
Yes, but, my lord, absolutely. And this note is only dealing with the question of precedent, not with those other issues about the types of distinction. But yes, and of course, what also then gets into the problem about people protesting on land and the sort of
Well, and protesters bring Article 10 with them.
Yes, exactly.
Which travellers don't.
Travellers don't bring Article 10, they bring Article 8, but yes.
Well, that's the question, isn't it? What is the extent of the Article 8 right?
So the article, the question which my lady posed me yesterday about Article 8, and I'm from Mr. Willers is going to have some more to say about that general issue, so I wasn't proposing to go into that. But subject 2, I do have a point about Article 8 of local residence, which I said I would park as I was dealing with that in my submission. I'm going to come back to that point. Similar, but on precedent then I've got scenario 1B, which is if Canada Goose can't be distinguished or confined in that way, and if its binding reasoning is that it is not permissible generally to grant final injunctions against newcomers, and this is the direct conflict scenario. And I've said that applying the first exception in Young, this court would be bound to choose between the conflicting decisions. But there is a slightly, well, there's an important postscript to that, which is that, of course, yesterday I suggested that that exception might not apply in this scenario because Canada Goose isn't, as it were, just a case of inconsistency with an earlier decision, but might be said to explain those decisions as being confined to interim injunctions. Now, my Lord Justice Lewison referred me to the case of Starmark Enterprises, and I've handed that up, and my Lord, could I just take you through that briefly, just to show you what he said there. The case, in fact, concerned whether one could displace, by a deeming provision, a presumption which normally arises that time is not of the essence in commercial leases. So that's the context. There was one Court of Appeal case called Awada, which had held that it could be displaced, and a later case called Mecca, which distinguished Awada and held that the presumption could not be displaced. And
well,
on the first,
it could be, but it wasn't.
it could be, but it wasn't in that case. Yes, yes, yes. Yes, it could be that was how it distinguished Awada, but it wasn't in Mecca because of the different drafting of the deeming provision. So you'll see on the first page, the summary at 2, where the ratio of an earlier decision of the Court of Appeal was directly applicable to the circumstances of the case before the Court of Appeal. But that decision had been wrongly distinguished in a later decision of the Court of Appeal. In principle,
Where are you reading?
I'm reading in the head note, my Lord, the first page, paragraph 2.
Under the holding.
Yes.
Holding 1?
I'm just going to paragraph 2, which is the key one.
Yeah.
So, paragraph 2, where the ratio of an earlier decision of the Court of Appeal was directly applicable to the circumstances of the case before the Court of Appeal, but that decision had been wrongly distinguished in the later decision of the Court of Appeal. In principle, it was open to the Court of Appeal to apply the ratio of the earlier decision and to decline to follow the later decision. And the discussion of that one sees in judgment of Lord Justice Kay at page 320, paragraph 62. Lord, rather than read this out, could I simply invite the court to read 62 through to 65?
And you'll notice that although not referred to in the judgments, both Young and Rickards were amongst the cases cited.
Yes, yes. Yes, and Ricard is the other case that I'm going to come to. Yes. My Lord, the other passage to draw your attention to, Lady Justice Arden agrees with the outcome, but there isn't a passage in her judgment that I wanted to highlight, but I did want to draw your attention to Lord Justice Peter Gibson, the last page, paragraph 97.
Yeah.
Now, my Lord, I should say, Mr. Gibbon has very properly drawn my attention to a very recent decision of this court with my Lord Justice Lewison, the Royal Mail litigation case, which I'm very sorry to say did not pop up in my research of Starmark. It's from July this year, and it considers Starmark. And my Lord, there's only one copy in court.
Well, what's it called?
It's called the Claimants in Royal Mail Group Litigation and Royal Mail Group Limited. And the neutral citation is 2021 EWCA Civ 1173. Now, my Lord, all I've done is, in the few minutes I've had this case, notice that it discusses Starmark, and clearly you will need to be aware of it, but I'm afraid I can't at this point make any submissions on the basis of it. Maybe that I come back later or put in a short email to the court.
What we decided in that case was that although we had doubts about an earlier decision of the Court of Appeal, we couldn't say that it was wrong, and therefore we followed it.
I'm grateful.
And you gave leave to appeal the Supreme Court on
You
that point.
gave permission to appeal.
We gave permission to appeal on that point.
I've got it on my screen. That was an appeal from Mr. Justice Mann.
Yeah.
And it was a judgment to the court.
Yes, and it comes right at the end of the judgment on the question of limitation periods applicable to injunctions.
And you said it was not open to you to depart from the ratio of UB Tiger. Yeah, okay.
My Lord, the second scenario addressed in my note then is if it's not thought to be part of the binding reasoning of Gamma or Ineos, that it's permissible to grant final injunctions against newcomers. Now that scenario does, if that's right, I think pose rather more difficulty for this court. Clearly, when one comes to Canada Goose, it might still be possible to distinguish Canada Goose, in which case, on this scenario, there wouldn't be any binding authority either way on the issue before this court. But if it were not possible to distinguish Canada Goose, then this court would be faced with a situation where, on this particular scenario, the only binding authority on the issue would be Canada Goose. One couldn't say it's inconsistent with earlier authority. It wouldn't be inconsistent. It would be based on this hypothesis on a misunderstanding of Cameron. So the question which then arises is, well, is that enough, essentially, to depart from Canada Goose? And that, my lord, is a difficult question, and that's where I think the Rickards case comes in. It's the other case which I've handed up. You will see again, just picking it up on the head note on the first page. What had happened was that a husband had failed to file a notice of appeal within the prescribed time limit. The judge refused his application for leave to appeal out of time, but granted him leave to appeal against the refusal to the Court of Appeal. In an earlier Court of Appeal decision, Podbury, the Court of Appeal says in the head note, applying the decision of the House of Lords in Laing, but that's sort of begging the question whether it was properly applying the House of Lords decision in Laing, had held that the court had no jurisdiction to entertain an appeal from a refusal to extend the time for appealing. And you'll see then held, picking it up over the page, essentially what the court held was its earlier decision in Podbury was erroneous, that since, given the nature of the present proceedings, there was no likelihood of the matter being reviewed by the House of Lords, and since the issue concerned the jurisdiction of the Court of Appeal, the court was justified in treating Podbury as falling within an exceptional category of case in which it was entitled to regard the decision as given per incuriam and to decline to follow it. And my lord, you will see there that there is a lot of emphasis placed on the exceptional nature of the course that was taken here. And the passages in the judgment that I should highlight are firstly Lord Donaldson's judgment from page 203. Where at B, his lordship explains that the court did err in Podbury in holding that Laing applied to applications for an extension of time. He says, accordingly, I'm confronted with the question whether we're bound to or should follow it and thereby decline to exercise an appellate jurisdiction, which I have no doubt that we have. He goes on to emphasise the importance of the rule of stare decisis, and at E, says that it may be in rare and exceptional cases permissible to depart from an earlier Court of Appeal decision if it is satisfied that the decision involved a manifest slip or error. And in the next paragraph, emphasising how rare this would be, His Lordship makes 3 points. At F, you'll see it says, first, the preferred course must always be to follow the previous decision, but to give leave to appeal, in order that the House of Lords may remedy the error. And then at G, secondly, certainty in relation to substantive law is usually to be preferred to correctness. And then just above H, third, an erroneous decision which involves the jurisdiction of the court is particularly objectionable, either because it will involve an abuse of power if the true view is that the court has no jurisdiction, or breach of the court's statutory duty if the true view is that the court is wrongly declining jurisdiction. Such a decision of which this case provides an example is thus in a special category. Nevertheless, this court must have very strong reasons if any departure from its own previous decisions is to be justifiable. It's only done so in one previous case. The same, that is agreed with, just very briefly, by Lord Justice Balcombe on page 2.
What was Williams and Fawcett about?
My lord, I have to pass on that question, I'm afraid. I don't know.
Right, okay. I'm sure somebody can find out. Right.
Lord Justice Balcombe briefly agrees with that on 206, just under H. and Lord Justice Nichols on 2010, starting from just under B.
£210.
210, starting just under B, my lord.
Yeah.
My lord, that's all I was going to say on that note and on those principles.
Thank you.
I want to come back to the point which I parked on the scope of the human rights exception. I'm going to deal very briefly with it, but I just want to outline the point because it is an important argument for the court to be aware of. The argument is, in a nutshell, this, that even if this court were to, as it were, follow Canada Goose, if I can put it that way, and uphold the judgment as a general proposition, the court could still find, in my submission, consistently with Canada Goose, that the judge went too far in ruling out the prospect of ever obtaining what he calls traveller's injunction. And in particular, the argument would be that even if the judge was right, as I say, about everything else, such an injunction could be appropriate if it is necessary and proportionate, in a particular case, to protect Article 8 rights of local residents. And just to put flesh on the bones of that, one can imagine a case, to give quite a strong example of such a case, where a person lives adjacent to a site which is being used by a rolling cast, as it's been put, of travellers and others, and where they may even have been made unwell by the nuisances, the noise, other sorts of nuisances from that site. And the reason I say they may have been made unwell is because, of course, in Article 8 terms, that clearly does engage a local resident's Article 8 rights, and the question then would be, well, is there then a power, or even perhaps a duty on the court to make a contramundum injunction? Now, I just want to pick this up in the judgment. It's in documents volume 1. It's on page 93.
No, paragraph, please.
Paragraph 233. So, paragraph 233, the judge poses the question, can the local authorities demonstrate that travel injunctions fall into the exceptional category, where the court is compelled to act by way of against the world injunction? In my judgment, the answer is plainly no. There's no doubt that travel injunctions engage the Article 8 rights of gypsies and travellers, see Bromley. Insofar as the remaining local authorities in the cohort claims now raise an argument that the relief sought also engages the Article 8 rights of the denizens of its area, then the court would be required to perform the required parallel analysis when considering whether to grant an injunction, and if so, on what terms. Now, if I just pausing there, my lord, the reason that it's put in that way, insofar as they now raise an argument that the relief sought engages Article 8 rights for local denizens, is that that wasn't how any of them had put the case. And so one does need to be quite careful of this, because this court may well be reluctant to opine on what the law should be in situations where, you know, it's all entirely theoretical, because there isn't anyone before you arguing on Article 8 grounds. So that's why I'm outlining the argument, but I'm only outlining it because what then happens is that the judge, having posed that question and said that it would require a balancing act, in other words, between the Article 8 rights of local residents and the Article 8 rights of travellers, the judge then follows in this judgment a discussion of what that balancing exercise would look like. And the conclusion, if one looks at it at 238, the conclusion of this section is a blanket conclusion. Traveller injunctions do not fall into the exceptional category that permits the court to grant a contramundum injunction. And I've skipped over the reasoning, but the reasoning is essentially to say that one could never satisfactorily perform the balancing exercise in a newcomer's case because you'd never have the travellers before you, just by definition, on a persons unknown application. And that's the core of the judge's reasoning. Now, my learned friends have not, as I say, didn't originally put their case on this basis. None of them have addressed you on whether there might be a sort of potentially narrow exception on Article 8 grounds, even if the judge is right on other matters in this judgment. It raises, though, quite a complicated and nuanced set of points about Article 8 and about how the balancing exercise would be conducted. And I've gone into that in some detail in my skeleton argument. But, my lord, in the circumstances and given the way the court, I think, is looking at this case, I don't propose, unless it would assist the court, I don't propose now to go through everything that I've said in my skeleton argument about that. It is another set of quite complicated arguments, which, as I say, really only arises if the court were to say that the judge was generally correct, but there may be an exception which he overlooked in a particular Article 8 case. So, my lord, if I may then go on to section 187B. On section 187B, the argument which I need to put to you to make sure you've had all arguments aired in court, I think is best characterised in this way. It is that section 187B does not have any different scope as regards newcomers, injunctions against newcomers, to any injunction under section 37 of the Senior Courts Act. So I put it that way because, of course, if this court's decision is that section 37 generally permits of injunctions against newcomers, other than in the traditionally recognised categories, then I think it would follow that so too does section 187B. I don't think there's a sensible argument that 187B would be any narrower in that respect. But if, on the other hand, section 37, that statutory jurisdiction, does not generally permit such injunctions, as the judge found, then the argument would be nor does 187B. So 187B does not have any wider reach.
Well, section 37 does permit such injunctions. It's what the judge described as a self-denying ordinance that says that they won't be granted.
Yes.
And as a matter of jurisdiction in the strict sense, the judge accepts that there is power to make such and to grant such an injunction.
Yes, my lord, absolutely. And so perhaps a better way of expressing what I was trying to express is that the self-denying ordinance which applies to section 37, if it does apply, would also apply to 187B. And there's no reason in the statute or in the preparatory materials, which is what's been relied on in particular, to suggest that Parliament didn't intend the same set of self-denying ordinances to apply. So section 187B itself is in the Bundle of Authorities, Bundle B, in section A, tab 7, which is page 19. And some emphasis was placed here on subsection 3. Rules of court may provide for such an injunction to be issued against a person whose identity is unknown. But of course that is generally true in the sense that under Section 37, injunctions can also be made against persons whose identity is unknown. It's a question about the scope of the self-denying ordinance, but in principle they can be in the contramundum cases. They can also be, just as a matter of course, against identifiable persons unknown. But the point I make about subsection 3 is that does not, in and of itself, suggest that any wider power or set of principles is intended to be applied under 187B. Now, Mr. Bowes then sought to persuade you that the drafter's intent was nonetheless to catch newcomers. He referred you firstly to the case of Test Valley, 1963 case, which had highlighted the problem of newcomers. But as far as I'm aware, and I'll be corrected if I'm wrong about this, but as far as I'm aware, that case wasn't actually cited in any of the preparatory materials that we have here as the reason for 187B, as the mischief which was being addressed. Mr. Bowes took you to Hansard, and I do want to go to that because Mr. Bowes didn't actually get to the punchline of Hansard, and I just want to show you what that is. It's in volume 4 of the authorities. I apologise, mine is book 4. It's tab D. So volume B, tab D. Within that is tab 3 or page 2299.
Page
2299. This doesn't have a title on it. Can I just mention for your note, this is the House of Commons debate on the 12th of March 1991, and it's in Hansard volume 187 from column 816. And Mr. Bowes mentioned that the minister had been asked about, or said some things about the particular clause that we're concerned with here. I mean, it's over the page at 238. And you'll see halfway down that page, Sir George Young, many Conservative members feel strongly about this matter. I had the pleasure of receiving a delegation from Honourable Friend, the Member for Horsham, when we discussed it at length. Clauses 2 and 3 will give local authorities additional powers, which may help with the problem that he described. The power to take an injunction against persons unknown will be especially helpful in dealing with gypsies because it is sometimes difficult to get their names from them. So that's all that's said. It's not that in my submission isn't sufficient to say, well, the very mischief that was being addressed was newcomers. What's identified as the problem is a difficulty of obtaining names from people. Of course, one deals with that by other means of identification. Now, the other preparatory material which Mr. Bowes referred to was Mr. Carmouth's report, which is referred to, extracts of it are referred to in the South Bucks case, but the report itself is also in this bundle. So it's tab 1, this tab D, then tab 1, page 2269. And various problems are highlighted. You'll see on page 2270 there's a heading, lack of urgency. And as that suggests, what's being discussed here is a difficulty of obtaining urgent relief. It doesn't, in my submission, it doesn't say anything about newcomers. there is a problem with clarity. It said in 2.8 on the next page, 2271, it's less clear in what precise circumstances the courts will be prepared to intervene. It used to be thought there had to be evidence of deliberate and flagrant flouting of the law. Thus, the power only became of any use when all other procedures had been tried and failed. However, in the Runnymede case, it was confirmed that the discretion is wider than this. But then at 211, he commented, these cases leave it uncertain to what extent the injunction can be used before an enforcement or notice or stop notice has come into effect. So that was one of the set of problems. There was a certain lack of clarity about at what point an injunction can come into effect. There was then, if one goes forwards to page 2274, said to be, well, there's a heading on inflexibility. All one has actually in this extract is the heading of inflexibility. But you'll see there was another section dealing with inflexibility. And then on the next page, what we have as the next page, 2275, injunctions, it said, as explained above, injunctions has proved a useful backup to the statutory system in difficult cases. However, there's still doubts about the circumstances in which the remedy is available. In particular, it's unclear to what extent it's available to restrain an actual or threatened breach of planning control before it has become a criminal offence, following service of an enforcement notice or stop notice. In my view, the authorities should be able to apply for an injunction in respect of any breach or threatened breach of planning control, whether or not an enforcement notice or stop notice has been served. There are likely to be two sets of circumstances where it will be especially useful. First, it can provide an urgent remedy in cases where there's a serious threat to amenity, to deal with either a threatened breach before a stop notice can be served or an actual breach, for example, where there are problems in preparing an effective enforcement stop notice in time. And secondly, it can provide a stronger backup power in cases where the existing remedies have proved inadequate. And so those are the essential reasons for the introduction of the provision. Of course, the provision deals with those because it makes clear that one can obtain injunctive relief on a prospective basis. But then just one final point, which is under 10.4, if such a statutory provision were to be introduced, the opportunity could also be taken to introduce some improvements. And you'll see that the improvement at 3 is this: to allow the remedy to be obtained in cases where there are problems in ascertaining the identity of those concerned. Have in mind a procedure along the lines of Rule 113 of the Rules of the Supreme Court, which allows orders for the possession of lands to be obtained against persons unknown. And again, the detail would be a matter for rules of court. But that, I must mention, that's as close as you get in any of this to a suggestion that newcomers are, as it were, the mischief which was intended to be addressed by the reference to persons unknown. I should show you...
Is it an Order 113 case? You would enforce the order against newcomers.
Yeah, you would enforce the... You'd get... that's right, you'd get the order against the persons... I understand you'd obtain the order against... Not against newcomers, but against persons who are actually there. But it would be enforced against everyone who's in the property. And that is... That, I think, as Mr. Giffen mentioned, that's discussed actually in Mere, which is where there's this slightly odd distinction between the scope of the order and what happens on the enforcement of the order. And it's a slightly unusual feature of possession proceedings. Lord Scott, in the South Bucks case, that's in tab C, so volume B, tab C, within that tab 32.
So what's the page number?
No, so it's the page I want to go to in the judgment is page 910.
910.
Paragraph 98.
This is Porter.
Yes, it is 40.
Did you say 910?
Page 910 of the bundle, but it's paragraph 98.
Yeah.
And it's only a general comment, but I just want to draw your attention to this. Section 187B, providing specifically in relation to planning controls an authority to bring proceedings that previously had been provided generally by Section 222 of the Local Government Act, authorise the local planning authority to apply for an injunction in support of planning law where the local planning authority consider it necessary or expedient for any actual or apprehended breach of planning control to be restrained by injunction. The criteria of necessary or expedient relate to the decision of the local authority to apply for the injunction. They take the place of the criteria set out in Section 222 of the 1972 Act. They're not criteria which apply to the court's decision whether or not to grant the injunction. Section 187B2 says that on an application under subsection 1, the court may grant such an injunction as the court thinks appropriate for the purpose of restraining the breach. This language does not, in my opinion, add to or subtract from the criteria expressed in Section 37 of the Supreme Court Act. The grant of the injunction must be just and convenient. If the grant of the injunction cannot satisfy this test, it can hardly be thought appropriate to grant it. Now, of course, it's not directly addressing the point which I'm here concerned
Also,
with.
did the other members of the appellate committee agree with Lord Scott's judgment, speech? I'm not sure they did.
Lady, I would need, I confess, to turn the pages to see what they
Yes, well,
said
I mean,
about
that's just a point to bear in mind. I've got a feeling they didn't, so it may just be one member of the appellate committee giving an opinion. But yeah, we need to check that.
I'm being given a partial answer. Lord Bingham agreed, but whether that
Right. I mean, I'm just keen that one checks because otherwise. It might not have the authority, it might otherwise.
Now, Ms. Bolton referred you to Pioneer Aggregate as an authority for the proposition that one shouldn't introduce principles of private law into planning law. That was an attempt to introduce the concept of abandonment. Similarly, Ms. Bolton referred you to the case of Newbury, which was an equitable estoppel case. But clearly they're very different because an injunction is a remedy, and it's a remedy which arises in any case, public law or private law. There are slightly distinct approaches in public law cases, principally around cross-undertakings in damages. But that's it. So to say that the principles which arise under Section 72 are the same as the principles which arise, I apologize, Section 37 are the same as the principles which arise under 187B is not to import a, quotes, private law principle into public law. It's simply to say that an injunction is an injunction which applies to a wide range of cases. And if there's nothing on the face of 187B, or indeed in the preparatory materials, to say that it was intended to have a wider reach, or for that matter, to suggest that in any case where public authority, because there are public authorities acting, should have different principles applied, then in my submission, the mere fact that 187B is about planning is not sufficient, doesn't provide a basis to draw a distinction. As regards
It's
to...
pretty unhelpful as well, if it's different because it's very hard to see why local authorities should be able to apply quite a different power to which private landlords don't have access.
Yes.
If exactly the same conduct is concerned.
Yes.
I mean, it might be the law, but you'd need some persuading it was.
My lord, the rules, in a sense, become a secondary point. But could I just draw attention to a couple of points on the rules? It's in Volume B, Tab C.
So page 73 in the bundle.
Yes, my lord, I'm grateful. So it's actually Volume B, Tab B, and then page 73. Now, the question was put yesterday to Mr. Bowes whether the language in 187B, which talks about issuing an injunction and needing rules to issue an injunction, the question was, well, does that mean issue a claim form, or does it mean grant an injunction? And on the face of it, it looks more like grant an injunction. And I agree with that. That is the ordinary reading, I think, of 187B. It's talking about rules of courts to grant an injunction. And Mr. Bowes said, well, if that's right, there aren't any rules of court. But I just wanted to draw your attention to how it's actually put in the rules of court. And it's a small point, perhaps, but on page 73, you'll see 20.1, we're in the practice direction here. 20.1, this paragraph relates to applications under 187B of the Town and Country Planning Act. And then 20.2, an injunction may be granted under those sections against a person whose identity is unknown to the applicant. So there is a symmetry there between what the Act says and what the rules say. In this paragraph, an injunction refers to injunction under one of those sections, and the defendant is the person against whom the injunction is sought. And 20.4, in the claim form, the applicant must describe the defendant by reference to a photograph, a thing, or any other evidence. And it then goes on to say the description must be sufficiently clear to enable the defendant to be served with the proceedings. The court has power to dispense with service, so there's a cross-reference back to the power to dispense with service. But the argument would, there's two parts to this argument. The first is, of course, it doesn't, as it were, create, it doesn't suggest that the court should exercise any wider jurisdiction than it would otherwise. So if what I've said about 187B is right, and that it wasn't Parliament's intent that this should be exercised widely, then clearly these rules don't cut across that and don't suggest that the court should take any different approach. The question, though, is what about the opposite scenario? If 187B is intended to have this wider effect, do these rules cut that back? And I think the only argument for saying that they do would have to be to say that where it is setting out the basis on which an injunction may be granted, at paragraph 20.2, that is limited by the description in 20.4, because it's explaining the basis, the circumstances in which the injunction may be granted, but that is different to the possibility that in a particular case one might obtain alternative method for service. But as I say, I think the point about the rules is very much the subsidiary point. The principal point is what was actually intended by 187B. only issue left on my agenda is to come back to the jurisdiction to review these final injunctions. Lord Justice Lewison yesterday put it to me that there's a distinction between, I think one could put it, whether the court can and whether the court should. And I agree with that, and I made that distinction in my skeleton argument. I described it slightly differently as a distinction between whether the procedural rules permit it, that's whether you can, and what substantive rules would then apply, whether you should. The argument under the procedural rules is, in my submission, reasonably straightforward. It is that the court does have the power procedurally to revisit them because under CPR 3.31, the court is entitled to exercise any of its powers on an application or of its own motion. Unless there is any contrary provision, but the only way of saying that there is contrary provision is to say that because, this is I think Ms. Bolton's point, because the orders say that people can apply, that should be taken as impliedly meaning that the judge can't exercise his own powers. Or because perhaps other rules of the CPR provide that parties could apply or affected persons could apply, then those rules should be read as it were, impliedly limiting the court's own power. But they don't on their face limit the court's power. And in my submission, there is 3.31 does provide the procedural rule answer to the question. On the question of whether the court should exercise its powers, there isn't any authority that I'm aware of on the facts that here arise, so ongoing injunctions against newcomers. Of course, there are authorities under the CPR provisions. I showed you one of them relating to what happens when a party who doesn't attend trial, when they make an application after a judgment, so there's authority on that sort of issue. But they're all confined to the circumstances of the case before the court, and there isn't an authority on the question which arises here. And that's why I don't think I can do any better than just make sure, my lord, that you have seen the judge's own reasoning on this question, because you weren't really taken through it yesterday. It's in the judgment, of course, page 63. So that's starting from paragraph 127. You'll see there's the heading, issue 1, so it's treated as issue 1, jurisdiction over final orders. There's then a description of Ms. Bolton's submissions, and forwards on page 66 is the start of the decision, and it's a lengthy passage.
Sorry, 66.
So paragraph 135, page 66. The judge said, Ms. Bolton's submissions represent the orthodox position where a final judgment is granted in conventional civil litigation between identifiable parties. The requirements of finality in litigation underpin the principles that she has identified. The analysis begins to break down once the attempt is made to apply these principles to litigation where the defendants are persons unknown. It remains conceptually sound if applied to persons unknown where the defendants are identifiable at the point to which judgment is granted. They're defendants to the claimant bound by the order. Their rights to apply or to vary or discharge the order will probably be as limited as the rights that would have been available to a named defendant. However, he says it's legally unsound to attempt to impose concepts of finality against persons unknown who are newcomers and who only later discover that they fall within the definition of persons unknown and after judgment has been granted. It's quite obvious that the permission to apply provision in the orders granted to barking, etc., were included precisely because it was recognised that it would be fundamentally unjust not to afford such newcomers the opportunity to ask the court to reconsider the terms of the order. And the judge then goes on to discuss the orders, which, as he has said, give right to people to challenge them. But if one goes forwards then to 141 on page 68, he says at 141, in my judgment, the inclusion of such a permission to apply in a final order is an implicit recognition that the relevant proceedings were not likely to have been brought to the attention of all of those who fell within the definition of persons unknown defendants. The permission to apply was a necessary but belated safeguard to prevent unfairness to such unnotified defendants. As Mr. Anderson submitted, between the relevant claimer and the newcomers, there could be no res judicata. That's clearly correct. For such newcomers, an application to the court to vary or discharge the injunction order would not be an attempt to relitigate. For them, it would be the first opportunity to be heard and to ask the court to consider their own circumstances. Could I just interpose to say that maybe that the concepts of res judicata don't really need to be relied on for this? And I say that because one thinks about an injunction against the world. If you breach it, you are liable for contempt. You can't then reopen it. That's what Gamel holds. And so it clearly does have some binding effects that can't be challenged in some circumstances. And I've, in my skeleton argument, I've gone into that in a bit more detail. But I just interpose there to say that there isn't, I think, authority for Mr. Anderson's proposition. It's relied on by the judge. I don't think it's a necessary part of his reasoning, but I just interpose to say it's perhaps not a necessary part. But he goes on to say the implications go further. And if I just jump down to 143, to an extent the debate about the particular provisions granting permission to apply in these cases is something of a distraction. Even had such provisions not been included in the final injunction orders, it's tolerably clear that such newcomers, not having been parties to the litigation at the time when the order was granted, would have been able to apply under CPR 40.9. Wilkinson, she was the advocate to the court, is correct to submit that the exercise by this court of any jurisdiction set aside over an injunction granted by final order is, in cases against persons unknown, dependent upon the nature of the judgment that the court has actually granted. And then the application point comes next. I can deal with Ms. Bolton's final point. The court can act only in response to an application to bear a discharge relatively shortly. During her submissions, I pressed Ms. Bolton as to how far her argument went. I posited the example of a group of 1,000 individuals who fell within the category, but who were newcomers in the sense that they set up an encampment. Assuming for the purpose of this argument the final injunction bound them as newcomers, Ms. Bolton's submission was that as the order was final, the court could do nothing about the injunction of its own initiative. The court could only act in response to an application to vary a discharge made by one or more of them. Further, even if one newcomer's application to discharge the order was successful, the court could only discharge the injunction in respect of the single person who had made the application. The injunction would continue to bind the other 999. And the O'Doherty case, he says, is different because it's inter partes litigation. And then one comes back to, at 146, the points which I sought to summarise yesterday, which is that the premise, really I think an important premise of this argument, this part of the judge's reasoning, is what you see at 146, which is linking it back to what he says fundamental requirement of justice, where an injunction has been granted by the court, has the potential to bind people who have not had the opportunity to be heard. The court must retain jurisdiction to set aside or vary the order, whether on an application by the person affected or, if necessary, on its own initiative.
There may be an analogy here with the grant of relief against sanctions. CPR 3.9 says that if you're in default, the sanction takes effect unless, quote, the party in default applies for and obtains relief from the sanction, unquote. And there are a number of cases in which it has been held the court can grant relief against sanctions of its own motion without an application having been made.
Yes, I'm grateful. My Lord, the judgment then goes on actually to address, in a sense, as the final issue, this jurisdictional, sorry, I should say procedural point. It's another point where slightly disagree with the, or suggest there's a slightly different line to adopt from the judge's reason. The reason is this: if one looks at 146, the judge goes on to talk about CPR, and at 147, what the judge says is, "I prefer and accept Miss Wilkinson's submission, advocate to the court, that final orders are granted by the court under CPR 40, and consequently CPR 3.17 continues to apply. By the same token," he says, "the court retains jurisdiction to act of its own initiative to vary or discharge a final order under CPR 3.3. Well, my lord, I've emphasised CPR 3.3. The reason I've done that is that I find it difficult to find in CPR Part 40 any provision that says the court may grant an injunction. So that part of that particular procedural limb seems to me at least to be open to question, but it ultimately doesn't matter because there's CPR 3.3. Injunctions are plainly granted under the statutory power, but they're not then made, as it were, under powers given to the court by the CPR.
I mean, the thing that bothers me about this is not really whether the court can discharge an injunction of its own motion, but whether it should, and the reason why it's trying to do so. And the reason it's trying to do so here, as we see from the Enfield case, is it all started with Mr. Justice Nicklin ringing the President of the Family Division at lunch on the
Queen's
2nd
Bench
of
Division.
October.
President of the Queen's Bench Division.
Queen's Bench Division, forgive me, on the 2nd of October 2020, and saying, "This iniquity has come to my attention in the case of Enfield, and I want to get all these cases together. Now the law has changed,
Yes.
and there are 5 cases that are in this order, and I'm very concerned about whether the law has been properly applied in these cases." Now it's all changed. He describes it as a sea change or something of that kind.
Yes.
Now that is, all this procedural stuff may be entirely correct, but is it appropriate for the court to do that when the law changes? Why do you stop at that? Why don't you just get out of the annals of the court 500, and there will be more, thousands of persons unknown injunctions that have been granted over the last 30 years, and discharge them on the grounds that the law's changed? I mean, that's not the way we operate, is it?
Well, my lord, the only thing I think which is said on that particular issue is actually the end of 147. The court will not stand idly by, the judge says, and allow an injunction to be enforced, a fortiori with the power of arrest, against persons who had no opportunity to be heard when the injunction was granted, in circumstances where the court is satisfied that the injunction should be varied or discharged. And of course, the context is a context where none of the affected persons in reality are going to be taking advice on the ongoing changes in the law, those sorts of things. So they're not themselves going to be bringing challenges to these injunctions.
Where does it stop?
Well, it's a matter, the court clearly needs to deal with it judicially, if I can put it that way. So the judge liaises with the president of the division and says there is a particular problem that's come to my attention in these cases.
No, but where does it stop? I mean, the cases before us are not all the cases of persons unknown injunctions. So we decide that the judge is right in paragraph 147. We've got to act. Right? Where does it stop?
Well,
how do all the other cases, how do all these other injunctions get discharged?
Yes, well, my lord,
in every part of the land.
My only answer to that would be one would have to expect the court, as I've just put it, to act judicially. In other words, to be taking action in contexts where the court considers it appropriate, and not to be taking action in cases where the court doesn't consider it appropriate.
I don't understand that. I really don't understand that. What does that mean? I mean, injunction is granted in Newcastle County Court, where they don't spend all their time reading Court of Appeal and Supreme Court authorities. And the circuit judge there doesn't know, and there's an application to commit a newcomer under an injunction granted 10 years ago in favour of the Newcastle Council. That's a disaster for justice if it it is held by the Court of Appeal, that that injunction cannot now stand. But I mean, what do? We have to draw. I mean, this is what is the consequences. It's not a question of acting traditionally, because I've no idea if anything like that has ever happened before in history. But we have to trawl through the books to see what orders there are and overturn them all.
No, judicially was the word I was trying to say, not traditionally. But maybe that also doesn't help. less confusing as a word to have been using. No, but my lord, the situation here, of course, was that the judge felt, and in consultation, let's say, with the president, felt that there had been a change and that this was a widespread problem, and that having come to his attention, put in place particular procedures to deal with the particular issue which had come before him. Now, it doesn't seem to me to follow that one would necessarily have to put in place procedures to try to surface issues in other cases. That's not what's been suggested, but it's simply that on the facts of what happened here, where it did come to the court's attention that there might be widespread problems, the court wasn't required to do nothing. That's the question: is the court then required to do nothing, or in that quite unusual situation, can the court say, well, given the unusual circumstances here, we do have a power, and we are in our judgment right to exercise that power?
So what happened in fact? The judge at 28 says that a questionnaire was devised, and in paragraph B, he says that the questionnaire seems to say any local authority not identified in the cohort claims, which has been granted a travel injunction, should provide the details to the judge's clerk. And then at D, it says, prior to the formulation of common issues, the court's objective is to identify those local authorities with existing travel injunctions who wish to maintain them. So was this sent out to every local authority in the country? Court sent it out to every single local authority? And if it did it send it out to other large landowners like the Forestry Commission or the Crown Estate? Or what did it do?
Well, my lord, I don't know what the court did. Others here may know, since they're representing local authorities. Whether the court actually sent anything out, I don't know. I wouldn't have thought that they were sent to other landowners, because that's not referred to. But maybe my learned friend has the answer.
Well, my understanding is the questionnaires went to the authorities who had the injunctions that had been identified.
That the court had identified.
That the court had identified. How the court identified those, I at least have no idea, but others may. But so the questionnaires were not universal. They went to authorities who had been identified by some means as having injunctions.
The court had identified it of its own mission.
Well, like this is also, I think that following judgment, in the Enfield judgment, Mr. Nicklin discussed with Mr. Wolfe, my junior, and Mr. Greenhall, and they asked them if they had information about the existing injunctions that were in place. I think that a list was collated eventually with their assistance, which was then used by the court with other information it had, then to send out to a large number of authorities.
Well, we've got 38 in the schedule.
Right.
And I don't know how many local authorities there are in England or Wales, but there must be a lot more than 38.
Yes. So I think that's how it arose, and the questionnaire went out.
My Lord, I have a copy of the Enfield transcript, and it explains that the Community Law Partnership, who were there for the interveners, were asked to provide assistance on the list that should be put together.
Sorry,
That's
say
how it
that
happened.
more loudly, please.
I have the Enfield transcript here, which I can hand up, which demonstrates.
You already got the Enfield transcript.
I think it's been emailed to the court as well.
Yes. That's what I was referring to. When
My Lord,
I asked Mr. Jones.
My Lord, effectively the court, the learned judge asked the Community Law Partnership, Mr. Johnson, if he would provide the list.
Who were representing travellers' interests.
Indeed, if he would provide the list of local authorities who should effectively be called in.
My Lord, I don't have a copy of the Enfield transcript. Thank you very much. But certainly my understanding is that Mr. Johnson was asked to do just that, and he did his best to try.
So the
and
list of
identify
38 is, as far as Mr. Johnson is aware, comprehensive.
Yes, I don't think there are. We don't know of any other local authorities that have a similar injunction.
So, my lord, I think that's all the assistance I can provide on that issue and on that topic.
Well, I mean, is there any other situation in which the court has done a similar thing? Ever?
I'm struggling to think of one, my lord. I'm not aware of one.
I mean, it just, looks, I'm afraid, like activism. I mean, when one reaches a decision as to the law, the next thing that happens is not that council stand up and say, well, now you've reached this decision as to the law, we must go back over history and make sure that we enforce it against other cases. I mean, it's very weird, isn't it? I mean, just as a sort of principle. I mean, the principle of finality just goes out of the window.
Yes, I mean, I'm hesitating not to repeat myself because I'm not sure that I can improve what I've said. I suppose the only additional point to make there would be that, of course, this, in a sense, the two parts of the judge's judgment go together because obviously it's an important part of both the issues before him, before you, the question of fairness. And one of the points which Mr. Anderson, I think, emphasised was that his injunction had secured fairness by having ongoing reviews. In other cases where there aren't ongoing reviews, if that's a necessary protection, as it were, for fairness, if that were a necessary protection for fairness, then it would be absent in cases where one didn't have that protection by definition. And so one's in a world there where one has decided that these injunctions don't have fair ongoing review provisions. And that was the judge's view. And it's in that lens that one then says, well, the court then, becoming aware of this widespread issue and having a power to act, is the court entitled to exercise that power in those quite unusual circumstances?
To which your answer is yes.
Well, yes, my lord. Well, of course, I've sought to discharge my function here by making sure that the court has all of the relevant arguments before you. That's what I've done. I can't think of any more, but I've tried to set them all out.
You submit the court should act. The court was correct to act.
Well, my lord, yes, in the sense that I'm putting forward the arguments. Yes, I'm putting forward the arguments that you won't otherwise have heard, and so I'm doing them to the best of my ability. And my submission has been that the court's right to act.
Okay. So you're actually putting forward an argument because there's nobody else taking the same point before us.
Well, my lord, in a sense, yes. I mean, my understanding of my own role, it's a mixed role under the practice direction, is principally to assist you by putting forward arguments that won't otherwise be heard. So, of course, one has to take account of the other arguments before the court. To be impartial, so I've taken arguments on both sides where I thought that's appropriate, where they've not otherwise been aired, and generally to assist the court. So I've sought to emphasise those which I think are strong, put less emphasis on those which I think are weak.
What I'm puzzled about, Mr. Jones, this is not a criticism at all. You've been incredibly helpful, and the court is incredibly grateful for all you've done. But what I'm puzzled about is reading out the judge's judgment, which we just looked at, and saying, well, there's no authority that says that's wrong, so it's right, is a submission which I mean, it's just as easy to say there's no authority and therefore it must be wrong. What research has gone into identifying the circumstances in which the court of its own motion has intervened in an analogous way? Because if it hasn't, then that's why the red flags are dancing up and down in front of my eyes.
Oh no, of course not. I've done very extensive research on that and on indeed all of the issues before this court. So had I found anything helpful,
So you've found
as I say,
the way it's been done before. So this is completely new.
That's why I've said that this is a new situation, my lord. Absolutely. And the reason I've read through the judge's judgment is not to simply say, therefore it's right. It's because as I say, I'm not sure that I can, in argument, improve on the reasons that the judge has given.
No, I see that. Okay. Well, thank you very much.
Well, I'm grateful.
So now, just to remind who you act for, Mr. Willers.
Good morning, my lords and my lady. I act on behalf, together with my learned friends who sit behind me, Ms. Tessa Buchanan and Mr. Owen Greenall, on behalf of the three interveners, the London Gypsy Travellers, Friends, Families and Travellers, and the National Federation of Gypsy Liaison Groups.
And you didn't all, did you appear below?
Yeah, we appeared below. I think I was with both my learned friends. My recollection is that they were my juniors in that case too. And certainly I was instructed and appeared together with Miss Tessa Buchanan in the Bromley case, both in the High Court and in the Court of Appeal, again on behalf of interveners.
Right.
And the three NGOs, non-governmental organisations, that I represent are those which are perhaps at the forefront of the representation of, certainly outside of court, and the protection of the rights of gypsies and travellers in all manner of spheres in our society. So they provide advice and assistance and often address policy considerations when asked to do so, and sometimes when not asked, but by local authorities and national authority too.
Right, thank you.
And there is a witness statement in the bundle from one of the employees of Friends, Families and Travellers that sets something of that out, but I'm not going to take you that now. So that's who I represent. The next question is, why am I here? And it's obviously of interest to the three NGOs that the voice of gypsies and travellers, and particularly those who wouldn't normally be represented in a persons unknown injunction case, are heard and considered. And who am I talking about when I refer to gypsies and travellers? Well, there are many definitions and meanings of gypsies and travellers, but primarily I'm talking about ethnic Romani gypsies, one ethnic minority group recognised under the Equality Act, and a separate ethnic group, Irish travellers, also recognised under the Equality Act, and then a third group who have already had a name check, new travellers, or what used to be known as new age travellers. And indeed, I represented the new travellers who were the subject of the Felton Wood wide injunction, ultimately granted by the Supreme Court in the Meyer case. That was a case involving new travellers.
And sorry to interrupt, Mr. Willers, when you say recognising the Equality Act, you mean in general terms, not specifically?
Well, there's nothing in the Equality Act that says that Romani gypsies or Irish travellers are separate ethnic groups.
No.
They've been they've been separately identified as
In
having
case,
protection.
But I just wanted to be clear that there isn't a specific
No,
provision in that itself. No.
Section 9, I think, of the Equality
Yeah.
Act is the relevant section, and then case law has recognised their ethnic identity.
Can I ask you about terminology?
Yes, certainly.
This court likes to act in a way which doesn't offend anybody. You quite happily use all the terms you have to describe your
Yes.
represented groups. But is there a term that, for preference, those groups would like the court to use, or not? I mean, I just want to make sure, really, that we don't cause inadvertent offence. We certainly wouldn't mean to do so.
I'm very grateful, my lord. It is something of a minefield, I have to say, because
That's why I'm asking.
when I speak about Roman gypsies abroad in Europe, I'm looked at aghast by many people from the Roma community who would rather not be called gypsies. They consider that to be a derogatory term. But in the United Kingdom, although many Romany gypsies refer themselves as travellers, Romany gypsies, spelt with a capital R and a capital G, is a term which many, and indeed most, ascribe to and would like to be identified as, and quite separate from Irish travellers, who again, if your lordship would be so good as to perhaps, when giving judgments, identify them with a capital I and a capital T. Now there is.
How do you spell gypsies?
Well, the first word is Romany. I spell it Romani rather than Y, but it seems to be a more current way of spelling that word. And then gypsies, capital G Y P S I E S, as opposed to what you may find in some judgments, G I P S I E S.
I've noticed.
Yes. I think the spelling that I've given you is the one that has been adopted more recently in most of the judgments that you'll find handed down in these courts.
So if we were to describe the group that you represent and that we're talking about here, or the groups, they would be threefold. They would be Romany gypsies, spelt as you've said,
yes.
Irish travellers, spelt as you've said, and new travellers, I take it with a capital N and capital T.
Capital N and a capital T, although they are not recognised as a separate ethnic group.
No.
It's more a question of lifestyle, although some new travellers will have actually been travelling on the road longer than settled Romany gypsies, but they don't thereby, as it were, take on at least nobody has yet argued in front of this court or others that they take on a separate identity.
Do you have any numbers of those that are that live in England and Wales in the group?
Well, difficult to break down the groups, my lord, but putting aside Roma, people who may have come to this country in recent waves of migration, so focusing on indigenous gypsies and travellers, if I can put it that way, then I think the number is something of the order of about 300,000 people.
So it's a very significant part of our society.
My lord, yes.
That's 300,000 indigenous members
Yes.
of these groups.
Yes. I can't break down those figures precisely to tell you how many would ascribe to being Romany gypsies as opposed to Irish travellers, and I think the smaller group, I'll be corrected if I'm wrong on any of this by Mr. Johnson, who sits at the back of the court, are the new travellers themselves. But there are a large number of Romany gypsies and Irish travellers that live in housing, not necessarily by choice, but by necessity, perhaps in many cases, given that there is a recognised shortage of caravan sites. There will be some Romany gypsies and Irish travellers who, having perhaps moved into housing, would prefer to remain in housing and perhaps only travel in their caravans during the summer months.
Does your 300,000 figure include all of them,
It includes all of them, my lord, exactly.
whether settled in housing or not?
Exactly, my lord. And that's not to say that they've all filled in the census form and identified themselves as Romany gypsies or Irish travellers, because in fact, when the last census was carried out, I think the figure was something in the order of about 60,000 that identified themselves as such. There's now a box.
Is that the 2011 census?
Yeah, I think it is. It was, my lord, yes.
Yeah, because we've
And
done a 2021 one.
Yes, there's been a drive to, as it were, persuade gypsies and travellers to identify themselves as such. But there is a reluctance, you may appreciate, my lords and my lady, on the part of many gypsies and travellers to identify themselves as such because of the stark discrimination that they tend to face in all walks of life, including employment and access to other services. That is a sad fact, but it explains perhaps why the numbers are lower in the and represent something of a significant undercount in the census. But as far as, and this is perhaps the key point, as far as the numbers of gypsies and travellers, and I'll use that term collectively if I may, that live in caravans is concerned, there is, albeit it's something of a, there's a real debate as to how accurate it is, but there is, and has been for many years, a biannual count of caravans carried out by local authorities, some better than others, in terms of the procedure they follow and the figures that they report back to the relevant government department.
How many local authorities are there in England and Wales? Exactly?
Well, that's a very good question. I think it's under 400, but it's close to 400, I think Mr. Bowes said.
Yeah.
And the local authorities that provide these caravan counts, these biannual counts, are primarily the boroughs and the districts of England and Wales. And they record in the latest count, I'm hoping I can provide you with this, just as perhaps an insight. The latest count, which was taken on, I think in fact in 2020, so pre the pandemic, there hasn't been one since for perhaps obvious reasons as I understand it. January of 2020, they recorded 22,710 caravans.
Sorry, 22,710. Mm-hmm.
And of those caravans, 2,049 were situated on what are known as unauthorised developments. I'll just perhaps pause there to explain what is meant by that phrase. It's land, primarily land which is owned by gypsies or travellers and being developed, in other words, used for residential purposes as a caravan site without planning permission. So about 2,049 or 50 on that type of site, and then 694 were counted as being on unauthorised encampments. Now, an unauthorised encampment may be a lay-by on the side of the road, a piece of unused ground, a piece of common land, a car park. The sort of site that is identified in the injunctions that we're now dealing with. And they are distinct from those living on their own land in breach of planning control. And the type of, so if we're thinking about the cases we've been looking at, the Gamel case concerned an unauthorised development of Victoria View, Smithy Fen, land which was owned by, in fact in that case they were Irish travellers. Whereas the cases that are before us today concern those who have camped or are camping or intending to camp on what are known as unauthorised encampments, the village green, the school playing field, perhaps taking the worst type of example.
So that's the smallest number
Yes.
of caravans.
Yes.
You say 694.
Yes.
And we can assume that there'd be several caravans on each site. So it's a matter of hundreds of sites.
Well, my lord,
Low hundreds.
the counts are of caravans themselves, and what the figures show really is that there's about, and this is very rough, 10% of the overall caravans occupied by gypsies and travellers on land either owned by themselves without planning permission or alternatively moving around and stopping on sites without permission to do so.
In the case of what you call unauthorised development,
Yes.
it's almost always going to be breach of planning control, section 187B,
My lord, yes.
without any other common law cause of action.
Exactly.
In the case of unauthorised encampments, there may of course be section 187B, but there may also be other potential causes of action.
Yes, my lord, I'm going to suggest that section 187B was always designed to deal with unauthorised developments, and that it wasn't in the contemplation, you can reasonably assume, of the drafts people when they prepared section 187B that it would be used in this context to deal with unauthorised encampments. But parking that point for a moment, we know that there are about, and these again are rough figures, about 60,000 gypsies and travellers living in caravans. So we're really talking about 2, maybe 3, possibly 4 people living in a caravan. So those parked on unauthorised encampments, numbering close to 700 caravans, might equate to 2,000 to 3,000 people, something of that nature. But I do emphasise the fact, sorry my lord.
No, you carry on.
I do emphasise the fact that the biannual count is, and has been, criticised for many years for being an undercount. Because it really does depend on one day of every 6 months of the local authorities having the capacity and the knowledge to be able to drive around their local areas, literally spotting caravans, and sometimes not even asking who lives in them. So they can be very, very unreliable. But that's what we have in terms of.
And is it therefore right to say that the 38 defendants, 38 claimants, forgive me, to these injunctions represent all the injunctions that have been taken out by all the 400 local authorities in relation to the cohort of unauthorised encampments you're talking about?
I think it's right to say that as far as we know, as anybody knows in this court, and indeed outside of the court, including the NGOs that I represent, who have their, as it were, ears to the ground, we are dealing with the 38 local authorities that have taken the step of seeking a wide injunction. Now, your lordship will remember that in the Meyer case, there was an application for a wide possession order and an injunction. And ultimately, in that case, the Forestry Commission were granted the wide injunction, but not the wide possession order. And the Supreme Court overruled the Court of Appeal in the Drury case. And indeed, that line of authority, which I think stems back to a case called Jamal, concerned with the occupation of a university in Essex. And your lordship was talking about that kind of case. I think in discussion with my learned friends.
And
yesterday,
you
but-
say the Supreme Court overruled Jamal,
No, overall the case of Drury,
Drury.
which was based in part upon the Jamal judgment. The point about the Jamal judgment, just as an aside, is that it concerned different parts of the university, whereas in the Meyer case, the Forestry Commission was seeking possession of a number of different sets of woods or parcels of woods, which were some distance away from each other.
They got a possession order in respect of the wood, even though
Yes,
the occupiers weren't in possession of all of the wood.
they
But
did.
they didn't get a possession order in respect of other non-contiguous woods.
Exactly, my lord. And the short point that was argued on behalf of the New Travellers was that one cannot, as it were, obtain a possession order in relation to land which you haven't been dispossessed of. It was a very short point, but it was a point that Mr. Drabble had argued in the Drury case, and then came back to argue and succeeded in doing so in the Meyer case. And the Meyer case, from my research, seems to me to be the case which really created the possibility for the appellant local authorities to bring applications before first instance courts for a wide possession order relating to parcels of land in their areas.
Wide injunction, you mean?
Sorry, wide injunction. Forgive me. That's where I think that this jurisdiction really sees the light, the progenitor, as it were. And
When was that?
the Meyer case, my lord.
Yeah.
Yes, we can perhaps turn it up now. It's tab 9 of the key authorities bundle.
2009.
2009, my lord. I'm afraid for some reason, I don't have a bundle with pagination on it. And it's a bit like...
We'll work with you.
I've got my two juniors on the case, so page 181, I'm told.
Yeah, I don't have tabs, so
Ah,
they put me.
page 181.
I've got tabs in the key volume of authorities, but no others.
Okay, my lord, I'll do my best to be as swift as possible in making
Mr. Willis,
sure.
can I just interrupt you for a moment? How long do you expect to be first?
My lord, I'd certainly, with your permission, like to... I don't have as long as I thought I would have because I've given over some of my time to Mr.
How long
Jones,
would you
but-
like?
But I would still like, I think, until after lunch and possibly 2:45, my lord.
Right. And is that satisfactory for the reply people?
I should be going first in reply, and my current plan would be to spend half an hour if the court would allow me that.
And others?
Um,
What about Mr. Anderson, who went? I mean, are we going in the same order or different?
I can't imagine being more than 10 minutes, 15 minutes.
Right.
Well, Lord, I doubt I'd be more than 5 minutes, as things stand.
Ms. Bolton?
My lord, I anticipate I will be responding to a number of points by the advocate and Mr. Willers, so I suspect I'm going to be a good 30 minutes.
Right. Okay. Well, that sort of does make it a bit tight, doesn't it?
I'll do my best to...
So, Mr. Willers, if you could sort of aim for 2:45 as an absolute deadline. Now I've got more bad news. There's going to be a fire alarm in this block at 1 o'clock. So rather than all piling out of court as the fire alarm goes, I'm going to suggest we rise at 10 to 1. And since we're a bit stuck for time, I suggest we resume at 10 to 2.
Right, my lord.
If that suits everybody. So that shouldn't hurt anybody, but it is just what we'll do.
Certainly, my lord. Can I indicate, if it assists, that I'm certainly going to adopt and gratefully adopt much of what my learned friend, the advocate for the court, has said, but not all of what he said. And there are some points of distinction between the two of us, particularly on the question of precedent in this instance.
On the question of what?
Precedent and the flow chart that my learned friend has helpfully provided to the court. I wasn't intending to address in any depth my own friend Miss Bolton's point about whether or not one can reopen the final order. That has been addressed by Mr. Jones, and I think that I need to say little or nothing more about that. And unless your lordship would like me to, I don't intend to spend much time on the contramundum point. Like Mr. Jones, it may be that we ought to focus rather on the question of the jurisdiction for a final order against newcomers. So, with that, can I then take you back to the Meyer case, my lord? And you'll see, indeed, in the first page under the held, the references to the cases which your lordships may well be familiar with, my lady, the Hayman case and the Drury case, and Jamal being distinguished. We know what was decided in that case, and you've been taken already to Lord Rogers' speech, paragraphs 1 to 3. And there's a reference in there, paragraph 2, to one of the cases, the South Cambs District Council case against persons unknown. But then can I take you please to paragraph 25, where in Baroness Howe's speech she says the underlying principle.
Did everybody agree with her?
Well, I believe they did, my lord. I'm not going to suggest that they didn't, but it's obviously worth checking. But she says the underlying principle is where there is a right, there should be a remedy to fit the right. The fact that this has never been done before is no deterrent to the principled development of the remedy to fit the
Which
right.
paragraph?
Paragraph 25, it's page 2788 F in the internal pagination. The fact that this has never been done before is no deterrent to the principled development of the remedy to fit the right, provided that there is proper procedural protection for those against whom the remedy may be granted. So the questions are, what is the right to be protected? And what is the appropriate remedy to fit it? And then, can I invite your lordships to read paragraph 38 to 40 on page 2792. I only do that because I know that you'll be quicker at reading it than me reading it to your lordship. My lady.
And what she's talking about here are possession orders, not injunctions.
My lord, that's right. But then the court and Baroness Hale agreed that in a case which concerns where the issue is, can we provide a remedy, and it can't be a possession order, an injunction can be granted, a wide injunction, but it has to be, as she says in paragraph 40, specifically tailored against known individuals who've already intruded upon the claimant's land and are threatening to do so again, and have been given a proper opportunity to contest the order. So Baroness Hale's not giving, as it were, the court or court carte blanche to grant injunctions of this sort. She's very concerned that they are specifically tailored against known individuals who've already intruded upon the claimant's land, and they have that opportunity to challenge the grant.
And she's dealing with a slightly different kind of case.
She is. I agree entirely, but nothing in Maya, in my respectful submission, is inconsistent with what the Court of Appeal concluded in the Canada Goose case. So that's a case where the concept of a wide injunction stemmed from. And we know from the judgment in the Bromley case, if I can turn that up, ask your lordship, my lady, to turn that up, please. It's tab 16. .335, I'm told.
Yeah.
That paragraph 10 of Lord Justice Coulson's judgment, he describes a recent spate of wide-ranging injunctions has been aimed at the Gypsy and Traveller community. This process began in 2015 with Harlow District Council against Stokes, and then he tells us about the prohibition in the borough and the subsequent perception that the injunction had been effective led to a large number of similar injunctions in 2017 to 2019. Most of these injunctions, such as the injunction granted in the recent Kingston upon Thames case, as well as the interim injunction granted in this case, did not identify named defendants. The second and fourth interveners in this case all obtained similar injunctions following what were uncontested hearings. Then he says it appears that in total there are now 38 of these injunctions in place, so that accords with what we understand in this case. Nationwide, it would be unrealistic to think that their widespread use has not led to something of a feeding frenzy in this contentious area of local authority responsibility. First, these injunctions have had the effect of forcing the Gypsy and Traveller community out of those boroughs which have obtained injunctions, thereby imposing a greater strain on the resources of those boroughs or councils which have not yet applied for such an order. Secondly, they've created an understandable concern amongst those local authorities who have not yet obtained such injunctions to seek them forthwith. In other words, as Gypsies and Travellers are effectively forced out of one area, they move into another, and that local authority sees that...
Can I just ask about the difference between private and public land?
Certainly.
What is the 38 injunctions in favour of local authorities,
yes,
which you're telling me has been stable now for 2 years?
Yes, I
Has
think...
there been no others?
No, I think that may be something to do with the judgment of Lord Justice Coulson and the Court of Appeal in Bromley, but also Mr. Justice Nicklin's endeavours.
Right, yes.
I imagine.
What about private land?
Well,
Are there any injunctions of a similar kind protecting private land?
That I can't say hand on heart that there aren't, but I don't know of any that there are. And I mean, in terms of private land, possession is a private landowner can seek possession swiftly against trespassers using Part 55 procedure, and there is no need for the landowner, unless they're a public authority acting in their public capacity, to comply with the Human Rights Act, carry out welfare inquiries and so forth. So it's a fairly swift procedure.
HS2 is an example, I would have thought, of a private landowner,
yes,
which has got similar examples.
Yes.
And there may be others.
I don't know whether HS2 have any...
I mean, we know, do we not, that the Highways Agency has got wide injunctions against Insulate Britain, which covers almost the whole of the main road network in this country.
Yes. We do know that from recent events,
yeah.
And so there we have it. We have an example, but they are we're talking there about private landowners who do not have a responsibility to comply with the Human Rights Act. But the court obviously does in terms of its.
But I mean, how does
determination.
the insulate injunction fit in with the submissions that are made to us? I mean, how can you grant an injunction consistent with I mean, I don't know is the answer. We haven't seen the injunction, but we perhaps should look. Is it in the bundle?
I don't believe it is, my lord.
No. And
I haven't seen
is it in terms effective against persons unknown, members of insulate who are unknown?
My lord, the original ones were, yes, and they're desperately trying to name them because they will be caught by the same provisions. I think we have a copy of certainly some of the orders, but yes, they would be caught by the Dagenham position when they get to final order.
Sorry,
They would be caught by these proceedings as they stand at the moment.
but they're at the moment interim injunctions
They're
within
interim
the
injunctions.
principles in Bromley, and now what is happening is between interim and final.
Yes,
And is there a date set for final?
I'm not sure there is yet. I think they're still trying to identify defendants, but they will be caught by it at final order. So at that point, anyone not identified, the order won't apply to.
Well, unless your appeal succeeds, right?
My lord, indeed.
Sorry, can I just ask a further question? The Highways Agency is a public authority, presumably, is it?
My lady, yes.
Yeah. So it would be bound by Section 6.
My lady, yes.
My lord, your lordship said that the HS2 injunction would be, as it were, covered by Bromley, but I think your lordship would have meant by Canada Goose, because the Bromley guidance is designed to operate in the context of traveller injunctions. So the Canada Goose case is as I understand it, the key.
HS2 are protesters.
Yes, exactly. So Canada Goose is the key case there. And as Miss Bolton said, my learned junior indicated to me that what is happening at the moment is there are a number of named individuals, and there are still inquiries being made to identify one way or another the other defendants that can be added to the injunction. But I haven't seen the injunction myself. But as was rightly said, it's an interim injunction, so we're at the point where what is happening is not offending the principles laid down in the Canada Goose case.
And what about the climbing, the building?
The shard.
Yes. Well, not only the shard.
Or any urban exploring. I'm afraid I'm not an expert in urban exploring, and I can't assist you there, my lord. But,
but presumably, I mean, I looked at the injunctions, one or two of them, and they do appear to have been granted against persons unknown, and still to survive. Is that right or wrong?
It may well be right.
Well, there is still some activity in that regard, including in recent weeks, and there is a recent example of an urban explorer injunction being withdrawn in a hearing before Mr. Justice Nicklin, because the interim injunction having been granted and being effective, there were no defendants. And for that reason, the observations on the order discharging the injunction indicate that injunction was withdrawn.
Right, so it's all ongoing.
Yes. And that was in respect of a construction site in the City of London.
Yeah. I mean, have the injunctions granted in the Chancery Division been looked at? This all seems to be Queen's Bench focused, but my recollection, I know it's out of date now, the Chancery Division, is that we did these often. Is that a misrecollection?
Well, my lord, I've rarely appeared in the Chancery Division in any capacity, but certainly not in an injunction case. And it does lead me on to the next, and it may be that Mr. Justice Nicklin's diligence has been focused primarily on Queen's Bench cases and indeed those which he was made aware of.
I mean, there was counsel, Miss Holland, QC, used to appear in all those cases a long time ago. I mean, I just say that because she popped up in most of them, a bit like some of you before us today have popped up in many cases.
Yes.
And I mean, what I'm concerned about is that we're not just failing to be aware of other relevant activity, if I can put it that way.
No, I think it's safe to say that we have identified for your lordships and my lady all of the traveller injunction, wide injunction cases that have been brought by local authorities and that are either final or interim.
But there may be others that are not that are not. You say all the traveller injunctions, even if they're on private land.
No, all the traveller injunctions which relate to local authority land. It's obvious that those instructing me who do represent gypsies and travellers on a daily basis will come to learn of many, but not necessarily every case that is brought against gypsies and travellers. And indeed, given that many of the cases we're looking at are being brought against persons unknown, and the effect of an interim injunction against a person unknown is to render a breach of that injunction liable for committal, someone who breaches it liable for committal for contempt of court. It may be that other injunctions have been granted and the gypsies or travellers have simply avoided that land or moved on as soon as they've been notified of the fact that the injunction has been granted. So we can't say with any certainty that there haven't been injunctions granted to private landowners, which are wide injunctions in scope.
Yeah.
So, my lord, I was taking you to the Bromley case, and you've seen the paragraph 11, where Lord Justice Coulson identifies the, as it were, the popularity, increasing popularity of the wide injunction applications amongst local authorities, and indeed circumstances where local authorities felt constrained to apply for them, given that their neighbours had done so, and the effect of doing so would be to drive gypsies and travellers out of one local authority area into another. The case that Lord Justice Coulson and his fellow members of the panel were considering was an appeal in relation to a determination by Miss Mulcahy QC in the court below, whereby she had concluded that it would be disproportionate to grant an injunction, and indeed it was a final injunction, against or in relation to the occupation of land by primarily gypsies and travellers on, I think, 171 parcels of land within Bromley. The learned first instance judge did grant a final injunction in relation to fly tipping on those parcels of land. And as the representative of the interveners in that case, at first instance and in the Court of Appeal, I should make it clear that there was absolutely no submission on the part of the interveners in relation to the fly tipping activity. It goes without saying, you might think, perhaps it's trying to say so, but there are many elements of the traditional way of life of gypsies and travellers, and fly tipping is not one of them. The vast majority of gypsies and travellers are law-abiding citizens. And those whom I represent are here to represent the interests of law-abiding gypsies and travellers who either have nowhere to camp because of the severe shortage of sites, nowhere where they can place their caravan lawfully and live in accordance with their traditional way of life. And others who do have a place to stay, which is lawful. They live on one of the either local authority sites, which have been built up and down the country, or on their own private sites with the benefit of planning permission. But when they travel for work, as they must do, to comply with the requirement in planning law and policy, a requirement which means that for them to be entitled to what has been historically known as gypsy status, they must travel for an economic purpose. They must travel with their caravans in order to find work, but when they do so, they have nowhere lawful to stop.
Sorry, where does this notion of
Gypsy
requirement
status.
to have gypsy status, where does that come from?
It first appeared in statute, but is now embedded in planning policy, and the key planning policy document is a document known as Planning Policy for Traveller Sites.
Right.
The latest version was
Traveller
issued,
sites.
for traveller sites, yes. The latest version having been issued in 2015. And that's a policy which the government have issued, which promotes private site provision. And it's a policy upon which gypsies and travellers can rely when seeking planning permission for their own site on which to station their caravans and live. But in order to be able to rely upon that policy, a gypsy or traveller, ethnic or otherwise, needs to show that they continue to travel for an economic purpose. So the planning policy which
With their caravans?
In their caravans, yes, or with their caravans, I should say, yes. So the planning policy definition of what it means to be a gypsy or traveller is different from the ethnic definition. Remember, my lord, I mentioned that it was something of a minefield, this terminology in this area. But the planning policy definition requires one to travel for an economic purpose.
Is that in the bundle?
It isn't, my lord, no.
Could you let us see it, please?
Yes, certainly, my lord.
But that planning definition, well, let me ask the question, would that planning definition be relevant for the purpose of Article 8 as opposed to what you just called the ethnic definition?
Well, the planning definition at this point in time is subject to judicial review.
Well, maybe it is, but let's suppose it's a perfectly sound planning policy.
Yes.
What's its bearing on the issues that we are considering?
Well, the bearing is that gypsies and travellers, in order to benefit from that definition and either be entitled to seek planning permission for a gypsy site, with the benefit of that planning policy, or indeed continue to live on sites where there is a condition that the individual has to comply with that definition.
Yeah, as you said right at the beginning,
Yes.
these cases are not concerned with unauthorised development,
No.
to which the planning policy is no doubt
No.
highly relevant. We are concerned with unauthorised encampments.
Yes.
Now, what bearing does the
Just about.
planning policy have on unauthorised encampments?
It's this, my lord, and sorry I didn't get to it sooner. In order to travel for an economic purpose, one has to leave the developed site, the lawful site, travel around either looking or obtaining for or obtaining work, and stationing one's caravan somewhere whilst one is travelling around. And the problem is, with the shortage of sites, individuals who are continuing to travel for an economic purpose will be caught by these wide injunctions, just as those who have nowhere to station their caravan 24/7, 52 weeks of the year. So wide injunctions will
So your point then is that even if one of the cohort has a perfectly lawful base, if I can call it that, they will still be travelling with a caravan away from their base,
yes,
and will need somewhere else to stay temporarily.
exactly, my lord. And the problem is that without there being temporary sites, transit sites is the terminology used, or indeed the adoption in some, as there has been in some local authorities, of a policy known as negotiated stopping. Those gypsies and travellers who are continuing to travel for an economic purpose in accordance with the planning definition will find themselves pitching up on unauthorised encampments and will thereby be caught by these very same injunctions.
What is the nature of the economic purpose generally?
With the work, it will be. It can take many forms. You know, I'd be generalising, but let me perhaps just give you some examples. Tree surgery, selling of carpets, selling of beds, tarmacking, garden work. And more traditionally, it would have been hop picking, and it still does have some relevance. But whether it be hop picking or fruit picking or potato picking, that sort of thing. But most of those traditional forms of employment have died out as a consequence of mechanisation.
Yes, thank you.
So the wide injunctions catch both those who live on authorised sites, local authority run sites or their own, and those who have nowhere to go. And clearly they obviously catch those who are up to no good and are intent on antisocial behaviour or fly tipping too. But the problem is that the broad brush, as it were, is sweeping up those that I and represent, have an interest in, the innocent gypsies and travellers. And this is all reflected in Lord Justice Coulson's judgment in the Bromley case. He sets this out in quite some detail. Page internal pagination of the Bromley judgment, page 1048, paragraphs 2 onwards, you see the factual background. He identifies the history behind roving gypsies' occupation or presence in Britain, stemming from at least the 16th century, and Irish travellers since at least the 19th century. He says they're a particularly vulnerable minority, they constitute separate ethnic groups. So the reference there is to a case decided by Mr. Justice Gilbert. And he says in paragraph 5, a nomadic lifestyle is an integral part of gypsy and traveller tradition and culture. He refers to the Chapman judgment. We have the Chapman decision in our bundles, but I just perhaps will read, if I may, at the bottom, paragraph H, the quote from paragraph 73 of that judgment. The court considers that the applicant's occupation of her caravan is an integral part of her ethnic identity as a gypsy, reflecting the long tradition of that minority of following a travelling lifestyle. This is the case even though under the pressure of development and diverse policies, or from their own volition, many gypsies no longer live in a wholly nomadic existence and increasingly settle for long periods in one place in order to facilitate, for example, the education of their children. The court went on to say, measures which affect the applicant's stationing of her caravans therefore have a wider impact on the right to respect for home. They also affect her ability to maintain her identity as a gypsy and to lead her private and family life in accordance with that tradition. And then the learned Lord Justice goes on to say in paragraph 6, in the UK there's a long-standing and serious shortage of sites for gypsies and travellers. and I won't read through paragraphs 7, 8 and 9, but that statement is reflected in those paragraphs. My lady, Lady Justice Laing asked the question as to whether or not there was I think it was a European court case, but whether or not there is a case which identifies, as it were, the right of gypsies and travellers to station their caravans on land which they don't own, unlawfully in effect. And if we turn up, please, the Bromley case again, paragraph 40, page internal pagination 1060. You'll see there that Lord Justice Coulson refers as a starting point under the heading Article 8 in the Gypsy and Traveller Community to the Porter case. He identifies the case itself, and then...
I'm so sorry, I
sorry,
catch your paragraph number.
Yes, it's paragraph 40.
Thank you.
Internal pagination 1060.
Thank you.
And then he quotes extensively from Lord Bingham in paragraph 41 and Lord Bingham's paragraph 13 in the Porter case. Setting out the history. And if you turn over, please, to 1061, you'll see at paragraph B, or side paragraph B, their attempts to obtain planning permission almost always met with failure. And then he refers to some statistics which date back to 1991. The following sentence reads, but for many years the capacity of sites authorised for occupation by gypsies has fallen well short of that needed to accommodate those seeking space on which to station their caravans. Mr. Justice Sedley, as he then was in a case called Atkinson, alluded to this problem. And that passage is then set out in Lord Bingham's judgment. It says this: it is relevant to situate this new and in some ways draconian legislation in its context. And there, Mr. Justice Sedley was dealing with legislation brought in by the Criminal Justice and Public Order Act in 1994. For centuries, Mr. Justice Sedley said, the commons of England provided lawful stopping places for people whose way of life was or had become nomadic. Enough common land had survived the centuries of enclosure to make this way of life still sustainable. But by Section 23 of the Caravan Sites and Control of Development Act 1960, local authorities were given power to close the commons to travellers. This they proceeded to do with great energy, but made no use of the concomitant power given to them by Section 24 of the same Act to open caravan sites to compensate for the closure of the commons. By the Caravan Sites Act 1968, therefore, Parliament legislated to make the Section 24 power a duty, resting in rural areas upon county councils rather than district councils, although the latter continued to possess the power to open sites. For the next quarter of a century, there followed a history of non-compliance with the duties imposed by the Act of 1968, marked by a series of decisions of this court holding local authorities to be in breach of their statutory duty to apparently little practical effect. The default powers vested in central government to which the court was required to defer were rarely, if ever, used. Now, the history there runs up to Mr. Justice Sedley's judgment in 1995, and by that time, the duty to provide sites, which had been laid down in the Caravan Sites Act 1968, had been repealed. The duty was actually repealed in the Criminal Justice and Public Order Act of 1994. Rather than requiring local authorities to provide sites for gypsies and travellers, the government of the day instead considered that private provision would be preferable, and issued planning policy which encouraged private site provision. And that planning policy circular of 1 of 1994 as it was the predecessor of the current policy which I mentioned to your lordships and my lady earlier on, planning policy for traveller sites.
What do you get out of this passage in terms of advancing the case you wish to make?
Well, I hope I get this, my lord, that one sees that that being the history up to 1994, one sees no real improvement in the lot of gypsies and travellers and their accommodation requirements, because there have been no more local authority run sites.
I understand that. And therefore?
And therefore they're in a vulnerable position, or perhaps an even more vulnerable position than they were back in 1994.
And therefore they shouldn't be injuncted.
Well, and therefore, given that they have nowhere to park when they're either moving around for work or alternatively because they've got nowhere else to go, Lord Justice Coulson and his fellow judges were quite right to restrict the ambit of wide injunctions as they did, and to provide the guidance that they did at the end of their judgment. But I was going to perhaps, for my lady, identify the European court cases to which Lord Justice Coulson referred in the Bromley case, at paragraphs 44 to 48, my lady, page 1063.
Yeah.
And over the page at 1064. And make this point, my lady, that as your ladyship rightly said, the Chapman case said there is no right to a home. That right doesn't certainly exist in express terms in the European Convention on Human Rights.
And that was a planning case, wasn't it?
The Chapman case was, yes.
That was unauthorised development, not encampment.
Yes, and the enforcement measures taken against Mrs. Chapman were of the order of prosecution, as I recollect.
And she was living on her own land.
She was living on a greenbelt site, her own land, and so not possibly, unless she was travelling for work, going to be subject to the sort of injunction we're dealing with here. But the Chapman case not only identified living in caravans as an integral part of the traditional way of life, but having regard to the vulnerability of gypsies and travellers within our society, and indeed within societies across Europe, concluded that there was a positive obligation on the state, and indeed its emanations, which includes obviously our courts, to facilitate the traditional way of life of gypsies and travellers under Article 8 of the Convention. Positive obligation to facilitate the traditional way of life of gypsies and travellers under Article 8. And the reference to the Chapman case for that conclusion is paragraph 96 of the Chapman judgment. And we do have the Chapman judgment. Perhaps ask if we could turn it up.
Page 742.
I'm very grateful, my lady.
It's the same bundle as the
Yep.
case.
Tab 27 for anybody who have the pagination. And paragraph 96 is perhaps just worth turning up because it's a page internal pagination 427. And there's a reference 6 lines down to another judgment, the Buckley judgment. And the court said this: as intimated in the Buckley judgment, the vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyle, both in the relevant regulatory planning framework and arriving at decisions in particular cases. To this extent, there is thus a positive obligation imposed on the contracting state by virtue of Article 8 to facilitate the gypsy way of life.
That's preceded by a series of observations explaining why the application in that case failed.
My lady, yes, it doesn't, with respect, detract from the positive obligation. I mean, the Chapman case itself was obviously decided on its own facts, and in that case, one of the factors that was taken into consideration was the location of the site in the green belt, a specially designated area, which was worthy of greater protection than undesignated land. And there was no clear evidence from the applicant that she had no alternative site to which she could resort should she be removed from the land by virtue of the planning enforcement measures that were taken against her. And indeed, the planning enforcement measures you might think were somewhat lenient in as far as they didn't involve injunctive relief. The enforcement measures were no more or no less prosecution for breach of an enforcement notice.
I'm going to suggest, Mr. Willis, that we adjourn. We're a little bit late. I'm sorry, I got carried away with Chapman.
Not at all.
But we'll resume at 10 to 2.
My